here, current scenario. So as Peter's alluded to there are a number of projects in construction that are obviously keenly affected by COVID. And those of you who have seen the construction press in the last week or so, those contractors who are now earnestly back at work have certainly reported a deterioration in output levels on sites. And I think it's Balfour Beatty reported something like only 75% output is currently being expected on most of their sites as they're working. Obviously, sites have been closed when we were forced into lockdown. I know that there are a number of contractors who did strive to commence work as soon as possible, hopefully abiding to the government guidelines and UK health guidelines in terms of things like such as social distancing. Without question, there's whether or not there's been delay to your sites, there will be disruption. The stock phrase now is the new normal, but there will be, without question, disruption to productivity on sites, even those that are performing. And I have heard from a number of sources that there are some trades that are struggling now to actually procure materials. So notwithstanding that we have sites that are open, there has been problems that in actually procuring materials. And I understand that one of the key products that is certainly difficult to resource is plasterboard at the moment. I'm not sure if any delegates have had similar experience, but I've heard that from 2 or 3 different sources, particularly around London. Now, clearly, at the bottom of the slide there, you can see some of the obvious causes of disruption and delays that we are currently experiencing in construction. Obviously, closure, and we'll look at in the forthcoming slides how one deals with that or has dealt with that, and the remedies that you may have under your contracts for delay caused by closure. We have got labour shortage. We've had obviously the shortages from people who have been ill through the COVID-19 virus and had to self-isolate. We've had, obviously there's instances clearly with the construction, as with other industries, of furloughing staff. So staff on furlough have actually dropped labour in any event. I've already mentioned the issue pertaining to materials, and I think that's going to go on for some time, unfortunately, with production at certain material production facilities at low levels. So that's not going to disappear in the near future. And of course, we have to look at the way we actually now work on sites, in offices, etc. And we'll look at that in more detail later. But one of the key ones, obviously, is the social distancing of 2 meters. And that is difficult, particularly on construction sites. And it's also difficult with basic operations on construction sites. Plasterboard is 2.44 meters long, but if you have to manhandle that or other large components like windows or heavy doors, it's likely that the staff lifting, manhandling that door or component are going to be less than 2 meters distant. The CIC, Construction Industry Council, has said that there may be instances where that does occur, but they should be limited on sites. But clearly, these matters and methods are here to stay for the foreseeable future. We all must abide by the public health guidance that does restrict this productivity to avoid, the pandemic further causing issues to the country as a whole. Right, Pete, over to you.
Thank you, Chris. So, as Chris says, disruption will continue long beyond the time when sites have reopened. And as Chris also alluded to, evidence from surveys is that the majority of sites are now reopened. But we're going to look at extension of time and financial relief, remembering that this is relevant not only to any period during which your sites were closed, but will also continue to be relevant as we go into the future, and remembering that the obligations in regards to notices are continuing. So let's first have a look at extension of time under JCT. Obviously, we're looking at relevant events. There you'll see on the slide 3 of the most obviously relevant events in relation to COVID effects of COVID. That's not to say that there won't be other relevant events that might apply in any particular case. So don't take it from me. Look at your project, consider the particular facts, and hit upon any relevant events that you think have caused delay. Force majeure is the first one we've highlighted as being likely to be of potential general application. Force majeure is a relevant event, and that is the entire relevant event wording you have before you. Force majeure, French language, which I think we all now know means superior force. What does force majeure mean in English law? It doesn't mean anything unless the contract defines it. So unfortunately, with JCT, the contract doesn't define force majeure. And the leading case on the subject, which is about 100 years old, Le Beaupin and Crispin, highlights the need for the definition of force majeure and the fact that it is interpreted by reference to its context. So that's not a very promising start if you're hoping to rely on force majeure, but the saving grace is the judge in Le Beaupin and Crispin went on to cite commentaries on the French Civil Code, of which force majeure forms a part, and he cited with approval the bit that says an epidemic is force majeure. If an epidemic is force majeure, then a pandemic most certainly is. I think, despite the fact that, as ever, there are arguments both ways, it would be a brave tribunal that decided that the COVID pandemic is not force majeure. So that's definitely one to consider. Employer impediment is the odd one out in this list because that is both a relevant event and a relevant matter. So if it applies, you will get both extension of time and financial relief. And we'll come back to that a little later on in the presentation. The other relevant event of potential general application is the exercise of statutory powers after the base date by the government. This is, I think, a more tricky one than force majeure in the sense that the exercise of the statutory power, as the clause says, has to directly affect the execution of the works. So it's not really enough to say, well, they've been affected by COVID, by the lockdown, by restrictions. You have to pinpoint which restrictions have had a direct effect on the execution of works. As Chris said earlier, the most likely restriction to impact on works is social distancing. It's not the only one by any means. But if social distancing has been the driver for either shutting down a site and or redesigning the layout of the site and work methods, etc., then there may be, there's some bad news, I think, in that social distancing is not enshrined in law. It's not in the regulations, the protection of public health regulations. It is public health guidance. And I think in England, for certain, there is an argument to say that if social distancing has affected the progress of works on site, it may not be the exercise of a statutory power. In Scotland, it's different because the Scottish government shut down all construction sites except those carrying out essential works. So that's much more helpful. Other governments, the French government, immediately shut down all public works as part of their lockdown procedures. But the English government has patted the industry on the back and said, carry on, chaps, but do it safely. And of course, if you don't, we have given the HSE additional funding, and we all know what might happen as a result of that. So don't take it from me. Don't fail to use exercise of statutory power as a ground for extension of time. But I think there are arguments, and my view is that force majeure is probably the stronger of those two, unless you can show that the direct effects of other provisions other than social distancing, which are in the regulations or otherwise enshrined in law, are the main causes of delay. We've talked about the need to examine the particular facts of your project, but also remember that many contracts are subject to amendment. Those amendments are generally made in favour of the employer. So do be careful. Don't ignore the amendments. They may be highly relevant to your rights to extension of time, particularly in relation to the giving of notices. As JCT is drafted, the notice provisions for extension of time, clause 2.27, the clause references, by the way, are all to the standard building contract. Those notice provisions are not conditions precedent. So condition precedent means that if you don't comply with the notice provisions, then your right to the extension of time is lost. Unamended JCT notice provisions are not condition precedents, but amendments may well seek to make them conditions precedent. So, as ever, it is always prudent advice to follow the notice provisions in the contract to the letter, to avoid having to have unnecessary arguments. The notice provisions are relatively onerous here, so you can see that the trigger for giving notice is when it becomes reasonably apparent that progress either is delayed or is likely to be delayed. And it is necessary to identify the causes of delay, including highlighting any that are relevant events to which obviously extension of time entitlements would attach, and as soon as possible give particulars of the expected effects of those relevant events, including the length of delay. And crucially, there is an obligation to update changes as soon as you become aware of them. So it's an ongoing obligation to give notice and update the information as you go, given that we are potentially looking at quite a long tail for COVID-related delay and disruption. You're going to need to keep a close eye on all of the projects where you've applied for extensions of time and make sure that the notices are kept up to date as per those provisions.
Okay, thanks, Peter. The next slide here deals with the NEC contract, NEC 3 and NEC 4. Many of you may be working on framework type contracts, which is usually still governed by the NEC 3 contract. NEC 3 is different to JCT in terms of extension of time and financial relief, whereby under a compensation event, often referred to as a CE, the contractor should be entitled where he can demonstrate the loss and time relief under section 6 of the contract, clause 60. Notification of a compensation event by the contractor is a condition precedent under clause 61.3 of both NEC 3 and NEC 4. The contractor must give a notice of a compensation event, often known by the acronym NCE, within 8 weeks, that's 56 days, of becoming aware of the event and for which the contractor believes is a CE. So there are 2 caveats there, but clearly with COVID-19, it's going to be a very difficult argument to say that you're not aware of the event. So with the current scenario with COVID-19, I'm often asked the question with NEC contracts, should one issue both an NCE and a risk event? The fundamental issue here is that as the event has already occurred, the early warning notice is in some respects futile because the event's occurred, so you have to go straight for an NCE. Any contractor or subcontractor working on a contract at the moment who has not issued an NCE, a notification of a compensation event for the issues affected by COVID, is somewhat late, shall I say. It's fundamental with NEC that you must respond and notify within the 8-week window, subject to those two caveats of becoming aware of the event and for which the contractor believes was a CE. The early warning notice, if you've issued one, should really possibly have been issued under NEC some way back in January, February, when it was becoming public in the news that there's issues in China and also in the Middle East, and then started in Italy. So that's when the early warning notice should have been issued that there may be an issue pertaining to a delay or a financial relief event. If the project manager under your project has already notified of the compensation event, there is no requirement under the contract under 61.3 for you likewise to notify. But beware, there are a number of NEC contracts that I have seen, particularly on frameworks, where the clause 61.3 has been amended so that even if the PM should have notified of a compensation event, the contractor is still obliged to do so. That's the caution there. If the project manager accepts that your notification is a CE, a compensation event under the contract, then he'll instruct you under clause 61.4, and that would be to prepare a quotation. Under NEC, you prepare a quotation in accordance with clause 62. Now, with NEC, the default position is that your quotation for a compensation event, which may well deal with both time and financial relief, is a forecast, or should be a forecast, of the effect of that event on your project. So on both time and cost, the contractor, by default, the default position, is obliged to make an assessment of the forecast of the effect on time, an assessment of the forecast on the cost that the event has caused the contractor to suffer. Let's move to the next slide. The key event that everyone has been relating to under the COVID-19 issue, the pandemic in NEC, is 60.1.19 in NEC. Under clause 60, there are a list of compensation events, and this is one of those. And there is the wording straight from the contract. It's an event which stops the contractor from completing the works, or stops the contractor from completing the works by the date shown on the accepted program. Those familiar with NEC, the accepted program is a key document and is often has to be amended by the contractor, usually about once a month. That's dictated by what is stated in the contract data, and an accepted program has to be updated or revised on every occasion the contractor is applying for a compensation event where there is a delay. So clearly with the COVID-19 issue, which we've already discussed, it's very likely it's going to be delayed, so the contractor would have to update its accepted program. Now, the reasons below for 61.19 at the bottom of the slide, the last three bullet points, is something which neither party could prevent. Well, clearly COVID-19 will fit under that category. And an experienced contractor would have judged at the contract date to have such a small chance of occurring that it would have been unreasonable for him to have allowed for it, and is not one of the other compensation events stated in this contract. Now, that middle bullet point there, which states an experienced contractor would have judged at the contract date. And this is important to distinguish between NEC and JCT. In JCT, Peter touched on a matter of a change in the law. Now, under JCT contracts, if there is a change in the law after in JCT the base date, which is a definition, and in JCT the base date is usually set at around the time the contract was tendered by the contractor, then you may well have entitlement. An example would be a building regulation change, or if there's government legislation affecting COVID, which has been, as Peter's mentioned, in Scotland, also to some extent in Wales, then you may have an entitlement. With NEC, it's predicated off the contract date, which is the date the contract signed. And quite clearly, that date could be somewhat later than the comparable base date in JCT. So beware. With NEC, if you're trying to measure something against an event, then in NEC it's measured of what occurred after the contract date. And clearly now, if you have got a new contract under NEC, or you're tendering for a contract under NEC, this clause will not respond. Because if you look at the last 3 bullet points, you as an experienced contractor in this instance would have known at the contract date there's a pandemic currently in existence. So one cannot rely on this clause 6119 for future contracts going forward. It's only for events where contracts are running and the COVID-19 has hit during the course of your contract. When you are assessing the effect of a compensation event with NEC, as I said earlier, by default in NEC, you're forecasting the effect on time, the delay, and you're forecasting the effect of cost for your quotation for that compensation event. Now with COVID-19, it's going to be very difficult to actually forecast, possibly, I would suggest, the effect of both time and cost now going forward to a contract that may be lasting, for example, to the end of this year, or that runs into 2021. Because once you've made an allowance within your compensation event as the contractor, and in NEC, you can make an allowance in your compensation event of anything that has a significant chance of occurring. So you can make an allowance, a contingency allowance in your compensation event for the effects of COVID-19 going forward. But who's got a crystal ball? How long is this going to last? So the big issue with NEC is that there may well have to be a situation where common sense is applied between the contractor and the project manager, and there may be an assessment, a forecast assessment you've made for the compensation event, which can be revised at some agreed timeframes in the future. If that agreement is not put into place and the project manager signs off and agrees your quotation for the compensation event, then it really in NEC is a line in the sand. That's your quotation, that's what's been agreed. You can't then go back on that and adjust an error or a forecast you've made in that compensation event. So with situations like COVID-19, where this might last for a significant period, I would suggest that there should be some common sense applied and there should be some assessments made and future assessments made against the same compensation event going forward. To the next slide. Another compensation event in NEC which may be applicable is a breach of contract by the client. Now this would only in effect apply where possibly the client closed the site unilaterally, where maybe you as the contractor or the subcontractor could have actually worked on the site safely in accordance with the Public Health UK guidelines and the UK government guidelines. So if there was a clear instruction issued by either the client or the contractor, if you're a subcontractor, that you're not allowed to access the site, then there may well be an argument there for a breach of contract. One thing I would say here generally is that the government particularly here and many professional institutions within the industry and various lobbies and bodies have suggested that there needs to be, in the current situation, current scenario, some common sense and pragmatism applied to this issue. So, and everyone's talking about collaboration and everyone's talking about trying to work together. So with these situations such as this, if there is a situation in the contract which is draconian, then there should be some, I would suggest, some common sense applied, and maybe looking at trying to overcome these issues with collaboration. Unforeseen event, as I said in the previous slide, 6119 is predicated from the contract date compared to the base date in JCT. With NEC, of course, you are entitled to both time and financial relief if you can demonstrate that under clause 63. Now 63 is the clause under which you assess time and or money for your compensation event. One should be aware in NEC contracts, unamended, the contractor owns his own float. The float that he has determined in his contract program is his to keep. We have got a question that's flied up on the screen. Presumably a COVID second wave could be argued as a new CE under NEC. I would possibly suggest if we have a scenario where the R number, as it's now referred to, is currently sitting below 1, and the government have allowed certainly construction sites to open, abiding by certain rules. If there is a new second wave, so there's another lockdown, I would suggest that probably would be a new event, which could be mentioned under NEC. That'd be my understanding there. I hope that answers the question. Going back to clause 63, as a contractor, therefore, you're going to have to forecast the effect of delay. You can make a reasonable assessment of that delay on events that are going forward. If you have a situation where either the contractor, if you're a subcontractor, or the client, if you're a contractor, wants a one line in the sand degree compensation event from day one, one is going to have to make some significant forecast of the effect of the COVID matter going forward, which would not support probably clause 10.1 in NEC 3 or 10.2 in NEC 4, which is, if those who work with NEC, that is the clause that says that the parties shall act in a spirit of mutual trust and cooperation. But certainly most government lobby and institutions are trying to encourage all stakeholders, all parties in this instance, to work together to try and overcome this difficult situation that everyone is currently experiencing. Okay, on to the next slide. Peter.
Okay, thank you, Chris. So financial relief under JCT, same pointers apply as to extension of time. Look at the particular facts of your project and look at any amendments to the contract conditions to see how they might impact upon matters. So our old friend employer impediment crops up here again. As I said earlier, that is both a relevant event and a relevant matter. The other one that might be relevant is variations. So if progress is affected and an instruction to increase resources is given, then that is a variation, i.e. in effect to accelerate works, and that may hang with it an entitlement to financial relief. So you can see here the circumstances in which financial relief might be available to a contractor are where the employer has done something. So as Chris said earlier, if the employer has been proactive and shut down a site or given instructions in relation to the operation of the site, then that is your cue to apply for financial relief. Other than that, I fear that the buck, as far as financial relief, not time, probably rests with the main contractor in most circumstances. But give careful thought to the particular features of your project and make the application if you think it can be justified. We have a lengthy question here. Thank you for that. JCT contracts, what is your view about the feasibility that you could make a claim on the basis that the local council government client is actually the agent of the UK government and COVID rules imposition via their delegated power under Local Government Act, etc. Thus, a JCT contract, could the COVID delay event be argued as actually an employer impediment? So both relevant event and relevant matter. That is an interesting thought. I think is a local authority an agent of the UK government? That's an interesting point of law. They are in some respects. I think that I think it rather depends on what I said earlier as to how proactive the local authority client has been in managing the site. So if a local authority shuts down a public sector client shuts down a site because that it is a matter of policy or guidance from above, then yes, I think that would be an employer impediment. If the public sector client allows matters to continue and leaves the onus on the contractor, I think it might be quite difficult to argue that the problem emanates from the government, and the public sector client is an organ of the government. I think it comes down to what I was saying earlier about whether it is the exercise of a statutory power. So I think you should be looking at what has directly affected the progress of works, what has given rise to additional cost, and consider whether it is as a result of a change in the law. So, as I said earlier, social distancing is probably going to be a major factor in most instances that has delayed progress. That will probably, in my view, not be the exercise of a statutory power in England, although it may well be in Scotland because of the different approaches of the two governments. Obviously, the change of exercise of statutory power is only a relevant event and not a relevant matter. So you will need, I think, some proactive steps having been taken by the client to which affect the operation of the site before you can argue that there is an employer impediment. A lengthy answer to a very good and lengthy question. Thank you for that. So moving on, financial relief, employer impediment, we've dealt with that. The key thing here is, of course, notices. Now, they may be affected by amendments to the contract conditions, but remember that under JCT, the notice provisions for claiming financial relief, loss and or expense are different to those for extension of time. Now, the wording of the contract includes the words provided always that the notice requirements are complied with. Now, they may not have intended it, the draftsman may not have intended it, but that gives rise to the possibility that notices are conditions precedent to obtaining financial relief. There hasn't been a case that's gone through the courts on the point yet. Obviously, the sensible advice is, as I said before, comply with the notice provisions of the contract to the letter and avoid having the argument. You don't want to be the one who learns the lesson that others learn from. Okay, so timing of notices, again, you've got to be quick off the mark here as soon as it has become or should have become reasonably apparent that regular progress is being affected or likely to be affected. So if you're asleep on the job, you'll probably fall foul of this notice provision. You've got to be aware and give the notice as soon as you think that there might be an issue with regular progress. You must submit all information that's reasonably required and requested to enable the contract administrator to form a view, and submit details of loss and or expense necessary to enable it to be ascertained. So again, a reasonably onerous provision there that will certainly in standard building contract will be driven by the CA, but do do make sure you follow the notice provisions to the letter if you can, and if you haven't, get the notice in ASAP and keep the information updated and current. Over to you, Chris.
Okay, thanks, Peter. This is really absolutely fundamental for any contractor, subcontractor in the industry. You've issued your notices under both the contracts. You're then trying to recover losses you've incurred, delays you've suffered. Now, it's quite a cliche, but the first point there is still absolutely vital in construction, and that is accurate contemporary records. Without those, particularly now with this current scenario, which is new to us all, really, I have to say, a claimant is going to struggle to actually be successful in their claim against the other side, either for delay or for costs. Without question, there's likely to be, unfortunately, I would suggest, a high number of claims that flow from the COVID-19 pandemic, and there are already it's intimation from the law courts and from various tribunals and nominating bodies for adjudication panels that there is already an upsurge, an increase in the number of disputes currently being filed by various parties. One could say it's inevitable, but unfortunately there is often the situation where people resort to dispute resolution very quickly as a means to try and recover some monies that they feel are justified to, maybe which it's a knee-jerk reaction, and one isn't prepared to actually serve or file that claim in the current situation. Now, if you have as a party accurate substantive records, then you're likely to be more successful than those without. Now, there's records, as was quoted by a tribunal many years ago, absolutely fundamental. Now, I know at the moment it's very difficult for parties, for contractors and subcontractors on construction sites to keep records. If your staff have been furloughed, you're on reduced staff levels in any event. So what we're trying to ask people here is to keep records with actually trying to cover other people's work activities and work streams on site, as well as their own. Now, the key examples here that I'm trying to relate back to COVID, are matters such as staffing levels and outputs compared to tender levels. You may have heard those delegates on this webinar this morning of the measured mile approach. This is a methodology applied where one measures the actual outputs of staff or activities on site compared to those activities are not affected by disruption. So you have an activity which has clearly been affected by disruption, and that may well be something that is a process or a procedure that's been inhibited by the COVID-19 recommendations, such as social distancing, etc. Maybe circulation around the site. Then one measures the output that the contractor is achieving, which is being hamstrung by those restraints being forced upon him, against something where the activity was not. Now, whether it's measured against an activity on site which has not been disrupted, or a baseline or the tender information, that's debatable. But to actually get the record in file, one needs to take contemporary records of what is happening on your sites, and that is the output levels that are being achieved. Second one is access and egress issues. Now, that is affecting us all, I think, in any event. Whatever site it is across the whole of the UK, this is a key issue. And if one is, which one should be, adhering to the social distancing guidelines on site, which is 2 meters, if you have a scaffold, even with a 6-8 board scaffold, it's lucky that it's going to be more than 2 meters wide to safely pass. So you're going to have circulation issues, you're going to have issues about one-way systems around scaffold, etc., and one-way circulation routes through your site. So in terms of deliveries of materials, they may have to come to a certain access point of the site and be carted on a certain circulatory system around the site to a place that is required. It could be double the length of the normal transit for moving the material, etc. That likewise applies to staff. If you're on a fairly large project, where you've got a man hoist to actually access your work team to their places of work. Man hoists are not that large. You've got another issue there with social distancing. I know the CIC have said that if you are less than 2 meters, you can do so for a short period. But I would suggest that certainly when circulation, access and egress, the social distancing should be adhered to. Productivity is, as I've said, is something that is going to affect us all. It's whether you're on construction, you're just in another line of work altogether. Because of the restrictions imposed by social distancing, we're going to be less productive in our activities than we were before. And as I said, to measure that in the construction site, one really needs to look at things like the measured mile approach. There are other processes like earned value, but in essence, one needs to look at what are the outputs of the site staff now, what would they have been in a normal scenario. And those records need to be kept. They need to be kept and they need to be contemporary. Material, labour and subcontract procurement. Many contractors now work to resource levels of probably 80 to 85% subcontract labour. So they're heavily dependent on the subcontract resources available in the marketplace today. Subcontractors have been affected, as have contractors, so no doubt they may have furloughed staff, may have reduced output levels. I've already mentioned about material resources, and there's clear issues manifesting now, and no doubt a number of the delegates on the webinar this morning will be able to confirm this, as I said earlier, where material procurement is a problem. So all these issues are going to affect your productivity on site. And if you put your notices in, as we've just discussed in the earlier slides, this is the next part of the jigsaw. And this really, from my perspective, with some bitter experience of this, is where contractors and subcontractors' claims fall down. Without these contemporary records, your claim is going to struggle. And disruption, which really, in essence, I'm talking a lot about here, because this COVID pandemic is going to affect your productivity, and that's really disruption, is one of the hardest claims to win in a construction dispute. It relies heavily on records. So records are absolutely fundamental here. Let's move to the next slide. Right, you may well be affected by actions by others that are beyond your control. If you are requiring information for third parties such as your design team, then as there may be design team members, professionals on the webinar this morning, everyone's been affected by COVID-19. They may have people who are off ill, they may have furloughed staff, so everyone's output level is going to be down. So one needs to keep records of information required from others, from third parties, local authorities, etc. Are your utility providers performing? I've heard instances where some utility providers have, because of the COVID-19 issue, have not been prepared to come to site. There are stringent procedures and methodologies on site that they are happy with. So there's issues of delay there. I mentioned about local authorities, planning consent, etc. All these things are going to be parts of the jigsaw that affect delay and cost claims on construction. Disruption. Under JCT, you may have relief from loss and expense. Under NEC, you may have relief as a compensation event. It's a more rosier picture for a contractor or a subcontractor under NEC because by default, the NEC contract, you're entitled to both time and financial relief where one can demonstrate it. Under JCT, as Peter has alluded to, there are less events which you're entitled to financial relief than you are to time. So disruption needs to be something that is under JCT, which you'll be entitled to a remedy under relevant event. Accurate contemporary records being maintained is actually vital, fundamental, and the records can start from basic stuff like the number of attendees on site compared to what you had 3 months ago, for example. The actual time frame that the guys on site are actually able to work. Clearly, the government are recommending that you have staggered lunch breaks, staggered rest breaks for the teams. You have staggered times when the staff actually arrive on site. And this is all going to affect productivity. It's going to be, as is called in the cliche, the new normal. So all these things need to be measured, and they need to be measured now. And I said to you, I know it's very difficult to do this with reduction in staff, etc., and everything else, and all the other problems we're now suffering. But unless these records are kept now, then there are going to be problems going forward when claims will not be met and will not be successful in front of a tribunal. Right, let's move to the next slide.
Okay, thank you for that, Chris. And just to underline what Chris was saying, how the sting in the tail of COVID is that it will continue to affect projects long after sites have reopened. The Build UK survey recently carried out, which Chris alluded, suggested that productivity is averaging 57% across their members' sites at the moment, but in London it's 56%. So this is a probably in the round a more serious issue, the post-shutdown disruption than the actual shutdown itself, because we just don't know how long it's going to continue. So the climate, again, as Chris has already mentioned, is ripe for disputes where revenue is short. It is human nature to look to contracts for claims that in better times would just be left untouched because it's more profitable to move on with the next job. So the avoidance and management disputes has never been more important than it is now. We all know that it's very much business as usual from adjudicators. Well, why wouldn't it be? It is a process that has been relatively untouched by COVID, and adjudication will inevitably still be the most popular form of dispute resolution to which parties resort in the world of construction, and it's supported by the courts, who are again adopting a show must go on approach. The courts have been open, even if only virtually, throughout, and their robust approach to the enforcement of adjudicators' decisions continues. But will you actually get your money at the end of the day in line with the adjudicator's decision or the judgment of the court? There is some new legislation on the horizon. It has its first reading in Parliament today. In fact, that is the Corporate Insolvency and Governance Bill, which heralds a new rescue culture. So what I think the government is driving at with this legislation is that it spent an awful lot of money keeping businesses and the economy intact. As financial relief from the government tapers off during the rest of the summer and comes to an end in the early autumn, the legislation will do the same job, i.e. to protect jobs, businesses, and the economy for the longer term. What that means is that it may well be that if your parties who owe you money have been, their finances have been affected by the COVID crisis, there are more procedures open to, or there will be more procedures open to them if that bill passes Parliament, and I can't see that it won't, given the majority the government currently enjoys. The House of Lords may make a few tweaks to the wording, and we will report on that in a future webinar. But by and large, it will be easier for a party who finds themselves under financial pressure to get statutory protection through the courts from their creditors. And in certain circumstances, this could even arise a situation where creditors are obliged to continue supplying that party, even though there is an unpaid debt in the past, provided, of course, that the supplies are paid for as and when they're made. So there is this interesting rescue culture on the horizon, which may in effect guide how we deal with the enforcement of contractual rights. Some of you may have come across a document published by the government, the Cabinet Office, entitled Guidance on Responsible Contractual Behaviour in the Performance and Enforcement of Contracts Impacted by the COVID-19 Emergency. If you haven't read that document and you are involved in the commercial side of things, I would recommend you have a quick look at it. It doesn't have the force of law. It's not binding. So don't take it too much to heart and give away your contractual rights by behaving in accordance with the guidance. But do bear it in mind. It is very wide-ranging. It covers pretty much every aspect of the performance and enforcement of contracts, and in particular mentions the granting of relief, either by way of extension of time or financial relief arising from delay. So it definitely covers the areas we've been looking at today. And you ask, well, why? Force of law, it's non-binding. And the answer to that is that it is guidance which is directed particularly at the public sector. So if you are dealing with public sector clients and you don't consider that they're behaving reasonably, then this is a document that you can quote back to them. I can't obviously I can't judge what effect it will have, but it's certainly worth a shout. And in cases where tribunals, adjudicators, or courts may have a discretion to exercise, perhaps in relation to typically the apportionment of an adjudicator's fee, the award of costs, non-compliance with this guidance is a factor that is going to be well worth mentioning. The guidance is, in fact, it could be read as a hint by the government to the industry to act in accordance with the guidance. And I think that is hope might happen is that voluntary codes of practice may be published with an eye to the guidance, and clearly the government is not ruling out the possibility of further legislation, and I think it will have an eye on dominant market players such as house builders, for instance, to see how they are conducting themselves in the contractual arena, and if the government considers that jobs and the economy are not being given due consideration and that parties are purely acting in accordance with their own financial interests in the instant case, then legislation is a distinct possibility. And as I said earlier, the government is in a strong position to get legislation passed at the moment. I mentioned earlier, for goodness sake, don't waive your contractual rights by reference to the guidance. Just use it as a guide to your thought processes in the avoidance and management of disputes, and use it in those areas where I've indicated it might be relevant, and any others that you can think of. But I think it's clearly another manifestation of the new culture that the government hopes and expects us all to embrace in order to make sure that all the money that's been spent on preserving the economy isn't wasted. And after all, that money is our money. We're going to have to pay for it through higher taxes, whether they're direct or indirect, over the short, medium, and long term. Over to you, Chris.
Okay, thanks, Peter. One thing that I'll probably just quite to add to the last slide that Peter mentioned there with this Cabinet Office guidance. I mean, the language is very clear here, and reading from that guidance here, it clearly says here, in particular, responsible and fair behaviour is strongly encouraged. And this is in relation to disputes, etc. And they do here recommend that, in particular, the disputes, especially a plethora of disputes, can be disruptive to good contractual outcomes. And the government would strongly encourage parties to seek to resolve any emerging contractual issues responsibly. So the government are recognising here that the outfall of COVID-19 is going to cause some problems for us all, but we need to be very sensible in how we deal with those. But the last slide here is about COVID-proofing your contracts. Now, anyone in construction currently, in any shape or sphere of the industry, must be ensuring that their current contracts, the contracts going forward, that they're currently tendering for or working towards, are COVID-proof. Now, as a starter for 10, one needs to have a clause, an express new clause in the contract, whether it be JCT, NEC, FIDIC, or anything else, that will give you relief for time for the effect of a COVID risk. Where you can, either as a subcontractor or a contractor, then one should also seek to achieve a provision where you have financial relief for a COVID-19 effect as well. Now, as I said to you earlier, under NEC particularly, where clause 60.119 deals with events which a reasonable contractor would not have foreseen, COVID-19 is here now. It's been with us for 2-3 months. So that event would not respond under a delay on a future contract that you're working on as a tender or about to start. So contracts going forward need to be COVID-proofed. That's all contracts. And they need to have COVID clauses in there. And they would have to have, possibly or likely, a new definition for what COVID-19 actually is. So that's the key thing to remember going forward here, is that we've got the current problems of our current contracts that have been affected by COVID, but we need to think ahead the risks that are going to happen and occur on future contracts because of COVID-19. Okay, I think that's everything on that one, Peter.
We've got another question here, Chris, which you might like to pick up along the same lines as the previous one. PPN 0220 can effectively the contractor impute onto the client the government's changes in the law in support of claims arising from delay.
Okay, so PPN 2, can I make a contractor any reliance on PPN when dealing with public sector clients relating to COVID claims? Possibly.
I mean, I think we could certainly throw back at them the guidance that we just talked about. My view would be the answer to that question is the same as to the previous one, that I think it's difficult to impute onto the employer the consequences of government of changes in the law or guidance from the government. I think you have to look to the contract and see whether there is a provision that would enable you to claim time or financial relief as a result of a change in the law or guidance, public health guidance. I think the latter is unlikely. Change of law, as we've said earlier, a lot of the COVID-related restrictions are embodied in the health protection coronavirus restrictions England regulations, which weren't made under the Coronavirus Act. They were made pursuant to the Public Health Control of Disease Act, which is a 1984 piece of legislation, but they contain things like the shutting down of particular businesses, pubs, restaurants, etc., and provisions in relation to self-isolation. They don't contain anything in regards to social distancing, and there is no express obligation in those regulations to close down construction sites, in contrast to the position in Scotland. So, I repeat what I said before. If social distancing is the cause of the problem, you might have difficulty shoehorning it into a change of law provision.
Yeah, I think I'd support that position entirely. It's a guidance note, and I think it's Gary who's asked the question here. So it's a guidance note only, and it really does. You need to have express provision in your contract to respond. But as Peter intimated, under this government guidance note here, paper, they are suggesting that if there's a clear pattern of clients, contractors, and subcontractors not behaving responsibly, then they may well start with legislation and introduce legislation. So it will be then force of law. So that's the point there.
Yeah.
Okay.
Government spent its money, and it's going to do its best to make sure it's not wasted. So thank you very much for joining the webinar today. Thank you very much for the questions as well. Some very interesting ones there, which we don't really have time to debate fully or do justice to. We are almost 10 minutes beyond the hour. If there are any last minute questions, we can take them with the greatest of pleasure. Otherwise, if you think of anything when you go back to your desk, wherever that may be, please give Chris or I a ring, and we'll do our best to point you in the right direction. Most of all, good luck in navigating this COVID affected world. Stay safe and healthy, and we look forward to seeing you at the next webinar.
Thank you.
Bye for now.